Hey, good afternoon, everybody. Welcome back to Law and Legitimacy in this 4th of July week extravaganza, where we broadcast during, well, at least what civilized people on the East Coast eat lunch at about 12:30 p.m. Normally, we're on at 8 a.m. every day, Monday through Friday, but this week Mike's got a house full, and we wanted to make sure that his garage would be quiet enough for these. So we selected a time that worked for him. Me, I'm just a working fool in the office this week submitting briefs. Keep an eye on the newspapers. We will have a brief filed in the U.S. Supreme Court regarding one January 6th case, probably by week's end, and we'll also be filing our post-trial briefs for a new trial in the Proud Boys case. Among the claims we'll make in the Proud Boys brief, it's written, somebody's doing the final edits on it for me now, is whether we were deprived of fair trial rights when Congress released its report blaming the Proud Boys during jury selection of our case. And then President Biden decided to run for office with lurid pictures of the Capitol and complaints about MAGA trying to undermine the Republic, just as closing arguments were about to begin. In no other context.
that little thing.
In no other context would the chief executive of a party at suit be permitted to make such extrajudicial comments about the integrity of the proceedings of the defendants. In fact, the congressional committee reported things as facts which we all in trial knew weren't even true. In no other context would this be permitted. My prediction is the court will find a context to permit it here, and off will go on appeal. But in any case, keep an eye on that, and that's life. Hey, speaking of the Supreme Court, it didn't take long to see new cries for court reform. Last term, after the Dobbs versus Women Health Center case, there were calls to change the composition of the court, if not directly, then indirectly. A direct way of changing its composition would be to add justices, and that can be done statutorily. Another way to change it would be to require some sort of retirement age or term limit. I'm not sure that can be done constitutionally. I think that justices are appointed for life and are removable only for cause, as are any other federal judges. So that would have to, I think, be a change in the law that would be prospective only and not retrospective. We certainly can add justices to the Supreme Court. The last time there was a threat to do so was in the New Deal era. In the wake of the Great Depression, Franklin Delano Roosevelt enacted a lot of legislation designed to more directly involve the federal government in the management of the nation's economy. Many conservatives on the Supreme Court found that these gestures violated the law, that they were unconstitutional, that the federal government had overstepped, or more to the point, in some instances, administrative agencies had overreached. And so on both federalism and separation of powers grounds, the Roosevelt administration suffered a series of stinging defeats, and administrative measures and legislation that many in Washington believed were necessary to address the social crisis of that time had people talking about adding justices so that the impact of the conservatives on the court could be neutralized. As this debate was nearing its conclusion, and I think Roosevelt was likely to lose it, one Supreme Court justice changed his votes on some cases. I don't remember which one it is. Off the top of my head, it might have been Sunderland. I'm not sure that I've got the name right, but that was the famous switch in time that saved 9. Once a New Deal piece of legislation was upheld by a new 5-4 majority, the impulse to change the court disappeared. Now we have an impulse to change the court flowing from multiple directions. We have those dissatisfied with the Dobbs decision and who view the return of the power to regulate abortions to the states as a constitutional sacrilege. And we have last week's decision in the affirmative action cases involving Harvard and North Carolina that have plenty of people hopping mad, including Justice Sotomayor, whose dissent is a stinging rebuke of the colorblind Constitution. She makes the claim that the 14th Amendment was never intended to be colorblind, and there is no end to the remedial efforts that this country could and should make to accomplish equality of condition, or something like that at least. And so we have a vision of the court that is heterodoxical to many, but orthodox to others. And those who feel dispossessed right now, who feel that affirmative action was the settled law of the land and ought to remain so, that a federal right to abortion is the federal law, was the federal law of the land and ought to remain so, that we ought to curb the Second Amendment, and that the court's reluctance to do so is a sign that we need a different type of justice. That the expanded power to express religious views, whether it be in the provision of your services on the marketplace, that is in web design, or in the creation of items that consumers want, that by means of some creative process, these are all tipping the court in the wrong direction, in the direction against the progressive agenda. And the only way to save the progressive agenda, these folks reason, is to change the court. Since these justices don't die off fast enough to suit anyone, let's just add a bunch, or let's make some of them retire. And of course, you know that Mrs. Ed, that jackass in a skirt, Alexandria Ocasio-Cortez, oh, she of braying ass mouth, would be at the front lines claiming that this is necessary. Not so fast, I say. On these close constitutional questions, decisions can go either way. And, I've long watched confirmation hearings of nominees to the court and thought that they were exercises in futility and exercises in having a court say as little as possible and to be as evasive as possible. The best example of that, Ketanji Jackson's recent confirmation hearing, where she could not define what a woman was and is. And, it's easy to ridicule that statement and say, well, if you can't tell me what a woman is, how are you going to find the courthouse door and you're disqualified? But the discussion was steeped in the sort of coded hypocrisy that we take as the norm in confirmation hearings now. There are groups that have agenda, and those agenda have different priorities, and those priorities are expressed in code words. So in terms of the extreme expressive individualistic identity where we are what we want to be, it would seem to me that Ketanji Jackson was doing no more than playing a disreputable game, and she's no worse than any of the other justices who've gone up there and have been coached and tutored to avoid stepping on landmines. And speaking of landmines, I don't know whether any wit will have the courage to file pleadings taking up Sonia Sotomayor's implicit challenge in her dissent. She expresses dissatisfaction with the colorblind Constitution, and then in her opinion, in her dissent, she doesn't talk about people of color. She doesn't talk about Hispanics. She talks about people who identify as people of color, people who identify as Hispanics, thus raising the realistic possibility that the court might be open to the following claim. A guy that you and I might regard as white, or a person that you and I might regard as a woman, decides to identify as something that our senses and common sense tell us they're not. Will their choice to identify as something other than what in fact they are result in a claim of discrimination? A blonde white guy, legacy of Harvard, from Mayflower descendants whose family owned slaves for oh so many generations, and whose family was a beneficiary of Jim Crow and the continuing legacy of discrimination in this country, decides that the best way to combat systemic racism is to identify as Black and to advance the cause of people of color in his own flesh. He applies. He checks the box for Harvard's admission. I identify as African American. They look at it and think, he's pretty good, this and everything else. Well, let's let him in. When he comes in, he's whiter than I am. What are they going to do with him? Are they going to say, wait a minute, you committed fraud? Or is he going to adopt the mantra of our times? Justice Jackson can't tell what a woman is. How am I supposed to know what a Black person is?
Well, and then how are we to be able to effectively look back just based on how they're going to catalog and create their statistical categories, right? So just taking that to the logical extreme, How is it that we're supposed to be able to, I guess, view someone who is accepted into an Ivy League institution who has identified by a certain number of intersectional characteristics, but based on the traditional way that we define people, or that we self-identify, how are those of us who are looking to perhaps bring a discrimination suit in the future supposed to rely on data that's recorded?
Well,
How will Harvard or someone in that position have recorded that acceptance, right, in terms of
data
their
doesn't exist
cosmetic
anymore.
diversity?
Data doesn't exist anymore. Preferences do, and God forbid you disregard the preference of a person who expresses the desire to be something other than what they are. But that's a playful response. I'm sure that there will be litigation to that effect. There probably already is, so far as I know, and I'm sure that should that sort of litigation reach the United States Supreme Court, Sonia Sotomayor will be retracting her identify as stuff, because something tells me, based on the comments she made in her confirmation hearings, that she not only identifies as a wise Latina, she thinks she is a wise Latina in the eyes of everyone else. And so, it may be that race is a social construct that you can use if you're Sonia Sotomayor and on that side of the bench to your advantage. And that white is not a social construct. That white is an immutable characteristic that therefore has enjoyed certain benefits that ought to be eliminated going forward. And it may be that that's what the Equal Protection Clause holds. And it may be that if progressives want to expand the court, they may find enough votes in the House and Senate, certainly not in this House and Senate, to expand the court and have themselves 13 or so justices. That would be a solution for today that might tilt the needle in one direction or another based on how honest the justices were in their hearings. But it would solve nothing in the long run, because the problems of living together remain profound and the law remains ambiguous. And it seems to me that so long as we have justices, we'll always have disagreements of opinion. I do not favor term limits. I do not favor age limits. I do not favor increasing the size of the Supreme Court. If we increase the size of the Supreme Court, we may get to a position that obtains in many appellate courts where all of the justices can't sit on one case because it becomes unwieldy. If we have 13, will we modify the bench so that 13 people participate in argument? At what point does an intimate collegial exchange of ideas among some of the sharpest minds in the country become a food fest and a free-for-all?
So two things here. T Girl, thank you for being here. T Girl in the Rumble chat says Obama's daughter was a Harvard legacy. What do you make of that, Norm?
Was she? Well, I guess she was. And she was also black, so she got a twofer. I mean, she was. Let's put it this way: she was going to get in. She was going to get into Harvard no matter what. I think Obama's daughter would have done it. I'd forgotten that her father, I guess, attended Harvard Law School. Where did he start? He started at a college in California, ended up at Columbia, and then when it ended up at Harvard Law School. I mean, I'm with Justice.
That's about as far back as you're in the mainstream allowed to look backward on Obama. So
I think I'm with Chief Justice Roberts. The only way to end discrimination on the basis of race is to stop discriminating on the basis of race. And if people can pack the court with votes sufficient to restore affirmative action, well, then they will. And those of us who are opposed to affirmative action will continue to litigate cases against it. Right now,
Second thing here, the image that I have on the screen is from the Washington Post article, and it says SCOTUS is illegitimate, but I blew it up a little bit just to emphasize what appears to be a couple of pentagrams here. Are you seeing the same thing? I just think this is an interesting photo to put with this story, right? There's a call for change on the Supreme Court. The context for the article is interviewing anyone and everyone who will go on the record across the political spectrum as to whether they believe that the court needs some sort of programmatic overhaul, right? Some sort of infrastructural overhaul, whatever you want to call it. And the headline here is that SCOTUS is illegitimate. But in the midst of all that, Norm, I can't help but to focus on this sign with the woman here in the background who's just standing there in a Christ-like stance behind someone from the NAACP who's clearly kind of riling up a few of the activists there. But with the pentagrams on either side of the word is, SCOTUS is illegitimate. I don't know if you
Well, aren't
make
those
anything of that
actually
or
hexagrams? Those are 6-pointed stars, not 5-pointed. So, I
this
mean,
is 1, 2, 3, 4, 5 here with the black 1, 2, 3, 4, 5, and I don't know what's inside of
no,
it. It kind
one,
of looks
two,
like a
three,
Star of
four,
David.
five, six. I mean, I know you're from
One,
North Carolina.
1, 2, 3, 4, 5. Right?
Go to the next one on the other side.
1, 2, 3, 4, 5.
No,
And
no,
there's
no, no,
stuff in the background. Yeah,
no.
I'm just making the observation because there's red behind the black, and the red actually appears to be a Star of David. Maybe I don't know what was scribbled there, but the black star itself is the 5-pointed star, and notably the point is down. Right. So
Yeah.
look, just making that observation. We don't have to go too far with it, but it's interesting to see that in real time in an
Troubling
article like
times.
this.
Troubling times. The leveling instinct remains what it is, and there is a great passion in the land to treat everything as identical to everything else, such that that folks remain indistinguishable, except when it benefits you. And then, of course, there are distinctions with difference. And the great conceit in the dissents in the administrative action cases is that a colorblind constitution is objectionable. And we need to have a constitution that enshrines preferences. There are plenty of us who believe the exact opposite, and that a constitution embracing preferences is not a constitution worth supporting. We have, at Law and Legitimacy, called for some time for a constitutional amendment to ban race-based transfer payments. When I first read the affirmative action decisions, I thought, well, that's no longer necessary. As I look at the reaction to the court's decisions, I just wonder where we're headed. Hey, speaking of where we're headed, what's going on with this lawsuit against ChatGPT?
So Bloomberg is reporting on this, and I'll put this on the screen. So Sam Altman, founder, creator of OpenAI, which is the sponsor of ChatGPT, the progenitor, if you will, they've been sued. And Norm, I don't know, did you catch what was going on earlier this week with Twitter's rate limit or rate limiting? Did you catch any of that where Elon Musk actually went on the record here? I can pull up a tweet
I
from
read it,
earlier
but
this
to
week.
be honest with you, Mike, I didn't understand it because I think that the term rate limiting threw me, and I just couldn't get my head around
Well,
what was.
rate limiting is the amount is Twitter artificially suppressing the amount of tweets that an individual user can view. In other words, they're limiting
Based
the
on what?
refresh rate based on here. The criteria are there right in front of you. So what Elon tweets: to address extreme levels of data scraping and system manipulation, we've applied the following temporary limits. Verified accounts are limited to reading 6,000 posts per day.
Who in their
Unverified
right
accounts.
mind reads 6,000 posts a
Well,
day?
how many posts per day do you read, Norm?
20 or 30?
You think? Is that how many are being refreshed into your timeline every time you scroll up? Because that's what's happening is there's a limitation on the refresh rate and how many new tweets are pushed into your
Well,
timeline. Remember, this is algorithmically driven, right? What
let
you
me
see.
understand this. So if I'm looking at my phone right now and I'm going on to the Twitter gizmo, the Twitter icon, and I've done it. And I've clicked onto my name, and now I see stuff. And the lower left-hand corner, I see material that has been culled for me. I don't know how deep that data field is. I don't know how much is included in it. Are you saying that when I click on and refresh, each one of those entries is counted against that 6,000 posts per day limit?
Absolutely. Every single tweet that you can scroll up and see in your timeline is an individual post that you are seeing.
So
And
is
so
there but when I look at this thing now, when I scroll down, there appears to be no end to it. And so
there's no limit now. So look at
6,000
the date on this.
is one refresh.
Well, and that's the question I'm asking you. I don't know the answer to the question that I asked you. I'm just asking if you had any idea because I certainly
No, I
don't.
don't.
I don't have any
That's what
idea
was a hypothetical
how
question.
many
And
posts per day I read.
I was looking forward to being schooled and taught by you. When I say post per read, how many things do I actually click on, open up, and look at? I might look.
Different calculus altogether, right? But it's what is being batched into your feed is how many posts you can access, right? And what they did here. This is July 1st, 1 p.m. And so the reason I bring this up, Norm, is because this article from Bloomberg It appears June 28th, right? And it says Chat GPT creator OpenAI sued for theft of private data in AI arms race. And the article goes on to talk about the scraping of vast amounts of personal information and data scraping, right? So it says OpenAI has violated privacy laws by secretly scraping 300 billion words from the internet, tapping books, articles, websites, and posts, including personal information obtained without consent, according to the lawsuit. It doesn't shy from sweeping language, accusing the company of risking civilizational collapse. So what was happening with Twitter, Norm, is that Elon Musk became aware that there were massive scraping efforts going on Twitter's platform. Its users were susceptible to this mass secret web scraping of personal data.
I want to stop
right?
you for a minute. I'm going to let you go on for a moment, but I want to make sure I understand the fundamentals. What is data scraping?
Data scraping is exactly what it sounds like. It's what's the right word for this? It's without discretion. It is trying to pull in as much publicly available data as physically possible, right? So
is it fair to say
avatars, names, whatever is available on the internet that can be pulled into a database, that information is being scraped into a central hub.
So if I post something on the database that says Mike Boyer has secret female admirers who contact me to talk about how handsome they think he is, if I post that online, are you saying that a data device might pull that information and put it into its own database?
It's a categorical certainty.
Okay,
100%.
so that's what scraping is?
Yes. So, well, and typically,
I've always
now
assumed
anything that you push into that platform is going to be property of that platform. So I want to make sure we distinguish sort of the user agreement and what we sign up for when we indulge something like Twitter, right? Versus what's happening for independent third parties who are not necessarily a party to that user agreement with us, right? An unintended beneficiary of that contract, aka, right? Tapping in with some sort of system and then pulling as much publicly available data without discretion. They're not looking for anything in particular. It's a volume game. They're trying to scrape in as much information as possible. And in this context, we're talking about for the purpose of artificial intelligence development, information that will help something like ChatGPT innovate on top of its current structure.
If I put something on Twitter, am I not opening it to the public to use any way they like?
Sure, but
that includes scraping?
Well, does it include for commercial benefit? And I think that's the question that you and I went back and forth about, because the first question was, well, isn't this sort of a fair use thing? And I said, off the top of my head, fair use is something that has nothing to do with an independent, monetization or commercialization without something more, right? Without obvious satire or changing the form and function of whatever is being, what is available in the public. Here we're talking about someone using vast amounts of public data indiscriminately to feed some sort of commercial, for-profit engine.
I want to back up for a second, because you used a term that you and I think, understand. General listeners may not. So fair use is a term that's used in copyright law. What is copyright law and what is fair use?
Copyright law is a branch of what we would consider to be intellectual property. And a friend of the show, Ron Coleman, is actually a trademark and intellectual property attorney. I actually came to know who Ron Coleman was by and through his Likelihood of Confusion blog. And copyrights they exist under the umbrella of intellectual property, which is essentially a body of law that protects patents, copyrights, trade dress, anything that someone can have rights in that are more a creation of their mind, and they arbitrage that in real space, right?
So copyrights are mentioned in the federal constitution. That's an enumerated power that Congress has the right to do that. And you keep using these words, these MBA words. What does it mean to arbitrage something or other? It sounds like
so arbitrage can have a few different meanings, and I use it as intelligently as I can, but I am from the South, so you have to excuse me. But when we have an idea in our head and we go to manifesting that into real space, so think a book, for example, right? You take words, a combination of words and phrases at a certain volume, and then you put them into a specific order on a page, right? And you organize by chapter and verse, etc. you can apply for and register what's known as a copyright in that. And that copyright protects the order of those words on a page in a combined and published work, such that
as uniquely the product of my mind. It gives me
Correct.
exclusive rights to the use of that material and the benefits of that material's use, correct?
That's correct. And so a copyright is distinct.
Fair use, then?
Fair use would be, so books are a good example, but not perhaps for fair use, right? Because books are large volumes of words. A better view of something like copyright would be on an image or a painting, something like that. You can register a trademark for an image, but you can also copyright an image, which is distinct from trademarking because that talks about the use of something else in commerce, right? Affixing some sort of brand or image or connotation to the sale of goods or services in commerce. A copyright in and of itself precludes anybody else from using that iteration without your express written consent. And so a fair use argument would be an exception to that copyright protection, whereby a copyright holder could enforce copyright law, statutory protections against an unauthorized reproduction or an unauthorized use of a copyrighted work. Fair use is where there is it's sort of I hate using this phrase because it gets taken way out of context or overly broadened, but a safe harbor of sorts. So that think of things like the late night shows where satire is used, right? Or comedians, for example, or what is it? The Bee, the Babylon Bee, right? Satirists in particular take advantage of what's known as fair use, right? So they can take something that would otherwise be protectable as a copyright, but they have transformed the context such that it is used in a way that is not intended for protection under copyright law, and thereby they can take advantage of sort of unsolicited or unconsented use of an otherwise protected work, right? And fair use in that respect means that you don't have to pay anything. You can make commercial use of it if you see, like, Roger Goodell's face on a T-shirt with a clown nose, for example, right? Although Roger Goodell may have rights in and of himself, right? Name, image, likeness, some sort of copyright protection, and he should, by all accounts, be able to control that. If somebody puts a big clown nose on Roger Goodell, who happens to be the commissioner of the NFL, Norm, if you don't know who Roger Goodell is, and he's a very unfavorable person in the public consciousness. And there are T-shirts that have a clown nose on him that are sold by Barstool Sports or have historically been sold. Though they are taking advantage of what's known as a fair use exception to copyright or some sort of intellectual property protection on name, image, and likeness.
Okay, so suppose I publish a book. I'm going to focus on the written word because that's what I produce, I think. And I have a digital publisher, and the digital publisher pays me for the rights to publish my book. And then the digital publisher puts the book online. Can that book be data scraped without consequence?
It appears that is exactly what's happening, Norm. Without consequence.
What's wrong with
without consequence? Yeah, without consequence was your main question, right? It can certainly be data scraped, right? And there are all sorts of ways that people can come about. For example, I often use paywall blockers to access articles from sources that I typically would have to have a subscription for. But if it's for my own personal use, there's no other third-party intended commercial benefit. It's extraordinarily difficult or, kind of fruitless to try and exercise those rights against someone who's using it that way. But in this case, where you have copyrights that are being pulled into a data algorithm for purposes of AI enhancement or innovation, and AI innovation in and of itself, something like ChatGPT, is paywalled, aka it's a product that people have to pay for in order to use. There's a number of various different issues that come up, and this article talks about much more than just the intellectual property perspective on this, Norm. There are a number of existing federal laws and that get at not being able to simply scrape data like that and then use it without some sort of violation of the Computer Fraud and Abuse Act, the Electronic Communications Privacy Act. There's also talks of invasion of privacy, larceny, unjust enrichment. There are a ton of.
I go back to a book that we talked about when you and I first met. Shoshana Zuboff's Age of Surveillance Capitalism. I mean, when we go on to Facebook, we log on for free, and we give Facebook access to all our data, which they sell to third parties for marketing purposes and whatever other purposes third parties use it for. And nobody thinks much of that. Is this just not a similar version of that?
Well, I would think that if it depends on what is really in the possession of OpenAI and Sam Altman, right? And to be clear, if a platform like Twitter finds that there is some third party presence on its platform scraping massive amounts of data that it has sworn to protect for its users, or it has contracts with its users buying through its license agreement or its user agreement, right? That's a bit of a problem. And I think on a level beyond just the application of existing law, I think that intuitively you and I can agree, Norm, that that's somewhat problematic. If
Yeah, no,
there
I
is
mean, I
some,
see problems there.
do what?
I see problems there. I don't know enough about the law to know which way the law is likely to break. Where's this suit pending? Where can we read a copy of the lawsuit?
So I'll pull it up right now for us. Let's see. Where is the lawsuit link? Here it is. So this is in this is in California. Nowhere else would it really be. And there's a bunch of unnamed plaintiffs, right? So this is part of the article talks about how the plaintiffs allege a credible threat to their personal well-being if named. So it's sort of a John Doe class action, and they're alleging more than $3 billion in potential damage. So I'll pull this up on the screen. Here we go. Northern District of California, and you'll see all the named plaintiffs here are just their acronyms, right? Their initials rather. And then you've got OpenAI, OpenAI Incorporated, OpenAI General Partnership, OpenAI Startup Fund, OpenAI Startup Fund General Partnership One LLC, et cetera, et cetera, et cetera, and Microsoft, right? Because Microsoft is alleged to be contributing $13 billion into artificial intelligence innovation over the next several years. And for that reason, their partnership with OpenAI is subject to the lawsuit. And you can see there, violation of the Electronic Communications Privacy Act, violation of the Computer Fraud and Abuse Act, violation of the California Invasion of Privacy Act, violation of California Unfair Competition Law, business professions. And then there's Illinois, same thing. Biometric Information Privacy Act, which starts to implicate a lot of stuff here, right? There's a 157-page complaint, right? And it's littered with allegations of violations and misappropriation of data and contravention to these various forms of law.
Well, this is a great suit, great get. I'm glad you brought it to our attention. I'll be looking at it soon. I can't wait to discuss it further. Let's make a point to stay focused on that. I noticed, just to wrap it up for the day, there was a great story in today's Washington Post. Check the banner out. How elite schools like Stanford became fixated on the AI apocalypse. Are elite institutions compromising reality by attempting to solve imaginary societal ills? Only the Washington Post could come up with something as ungainly as that. It seems to me that AI does pose threats to things we value, and the Altman suit that we just talked about it is a perfect example of it. It may be that the traditional copyright concerns, which involved discrete physical products, need to be stretched somewhat to accommodate the reality of AI. I'm not sure we even understand AI as an agent yet.
I agree. And I also don't think that because we don't necessarily understand AI as an agent, we don't understand our own, I guess, impact on the development of AI. And this article just quickly begins by talking about a certain individual who sort of self-selected to be part of a group at Stanford and back in 2018 that wanted to understand what people thought were the greatest threats to humanity, right? Sort of that apocalyptic moment.
Existential risk factors, yeah.
Right. And what they found was that people weren't really worried about AI insofar as misinformation or data privacy and these sorts of things that you and I have just been talking about, but rather that AI might try and solve a very simple problem and lead to human extinction. And that's kind of where I went with that byline is trying to understand why students at elite universities would be swept into this ether of believing that AI was that the first problems that we needed to focus on were the sort of like the world-ending problems, right? The extinction of the human race, right?
Well, that's where the grant money is. That's sexy stuff, right?
Well, and that's the same thing with the court packing stuff, or at least the Supreme Court thing. That was the one insight I wanted to bring. It wasn't relevant at the time, but in reading that article, it just appeared clear to me that the partisan divide on things like court packing and AI, because the Bloomberg article I brought up was, it spoke glowingly of Chat GPT and Sam Altman and OpenAI, and to the opposite, they spoke very condescendingly about Elon Musk and Twitter and those who were trying to bring fringe AI conspiracy theories into the mainstream. And I think that's sort of a chapter in this that isn't being talked about enough, is this growing arms race between the personalities involved in AI, right? Because remember, we talked about Sam Altman not being on that open letter to halt development and innovation of AI, right? But then somehow appearing later on, once it was announced that Elon Musk was moving forward through the FDA approval of Neuralink, right? All of a sudden, it's a problem with his AI stuff. We need to worry about the development of AI now. But I wasn't willing to sign on to this letter about halting development of AI globally because that affected my profit interests, right? But then I'll get, anyway, I'll get off my soapbox. But that's probably the more interesting part of this AI topic to me, is the personalities involved. Basically, Sam Altman versus Elon Musk at this point.
Well, let's take a look at that in the weeks to come. Hey, so one of the other topics we're going to be talking about, folks, as we move into the late summer, midsummer, late summer, early fall, is we're going to make a special reach out to law students. I want each of you to contact a law student and say they need to watch us. Mike doesn't know I'm going to ask for this yet, but we'll soon make a more formal push. We want to get copies of syllabuses, course descriptions for every course we can for law schools around the country, because we want to see what's being taught. So put out an open request to the law students in your life. Send us your syllabi. We will post a place where you can send them to us, maybe even just electronically. But we're concerned about the nature of the society that we're creating, and the expectations that the law is training those who enforce the law, lawyers, become judges, to expect. And look no further than the vast dissenting opinions and the majority opinions in the Supreme Court's recent work. And you see the country is very much up for grabs. We want to be on the front lines of educating the next cadre of lawyers coming forward. So send us your syllabi. We'll have something to say about them.
That's absolutely right. So, Norm, I'm looking forward to that. I'm also looking forward to the newsletter that we're preparing for as well. I think you and I have a conversation scheduled for later this afternoon with an important follower and viewer of Law and Legitimacy. So I'm really looking forward to pulling that together. I want to give a quick shout out to In the Cloud. Thank you again yesterday for the super chat, the $5 super chat that you gave us. We appreciate that. For those of you that value us and feel good about spending the $5 or something close there too, basically the price of a Starbucks coffee. Any support you're willing to lend, we're not going to shy away from. We could very much use that as we push forward in what Norm was just talking about. I also want to highlight a few of the comments that In the Cloud was giving us here in the Rumble chat before we get off, Norm. Talking about web scraping, In the Cloud says, crawling the web across different websites. They're called crawlers. They seek through the websites to find data based on keywords. The crawlers will scrape the data and pull it together. And then she also goes on to say, Microsoft provides the cloud storage and computing for OpenAI, which they use the Microsoft-based cloud computing offering Azure. So a win-win for Microsoft. OpenAI had to use cloud computing to have the hardware to power their programs. They would spend millions and millions of dollars to build and maintain the platform. That's why the Microsoft partnership was so appealing for OpenAI. So anyway, that's just a little bit more. And for those of you that follow on YouTube, perhaps go to Rumble, because these are the types of comments that we get that StreamYard won't allow us to put on the screen for you. Anyway, Norm, I'll stop rambling. Thank you for your time in the afternoon. Your phone's ringing off the hook. Law doesn't stop, I guess.
No, but legitimacy does. It can ring. I have more fun with you than I do talking on the phone. Thanks for listening in, folks. We'll see you tomorrow at 12:30. You know how to find us. Give us your support. Thank you.
Sounds good. I'm going to go get my tan on. See you later, Norm.
Yeah, you need it. I can tell you're looking a little pale there.
Bye.